All right, so the record should reflect Ms. Stefan was given a paper copy of her BSI. She's had an opportunity to review that. While we took care of some other matters.
Accepted that answer. Unless I said that I wanted to take a reader, not necessarily. I said I wanted to take a trial, and neither of you guys accepted that answer.
So we're done with that. I'm not talking to you anymore about going to trial.
Okay, but none of this, some of this stuff is not true. Some of this stuff is not true.
Okay, you're gonna have a chance to tell me what's not true and what is true.
You have it on here if it's true. You say that I fled the building. I left because you guys wouldn't accept my answer that I wanted to take the trial. I told you I wanted to take the trial, and you wouldn't accept that answer.
In about 3 minutes, you're gonna have a chance to tell me everything you want to tell me.
Okay. That doesn't change this though. That you wouldn't accept the answer that I said I wanted to take a trial, but you would accept that the plea deal, because that's the answer that you wanted me to do. I didn't want to make that choice. I stood right here and told you guys both that I wanted to take it to trial, and that answer wasn't acceptable.
Okay,
so why wasn't that answer acceptable?
I need to conduct this hearing. If you're going to keep interrupting me, then we're going to stop the hearing and then have you taken into custody. We're going to try it again at a different day.
Okay, because
I'm not going to keep listening to what you're saying because it's not correct. We had the hearing.
That is correct. I stood right here and told you that I wanted to take it to trial, and you wouldn't accept that anscer. You guys went ahead and pushed for the plea deal anyways.
We're going to revoke Ms. Stefan's bond. We're going to take you into custody at this time. You're going to be held without bond. I'm going to reset this for a sentencing hearing at a later date.
So what?
And you'll get jail credit towards your sentence for the time it's being held now.
Because you don't want to hear the truth about what happened. She said that I saw her, that I kicked and hit her, and I didn't. My cousin had to show up and spray us out of the house.
Because you keep interrupting me. Because you keep interrupting me, and I can't conduct this hearing.
Because you're not listening.
So for the record, my court will reset this for a sentencing hearing at a later date, and I'll notify counsel.
Here.
I'll also issue a written order revoking your bond and remand her to jail pending that sentence. Okay. Do you have any other matters?
I do have Miss Creed, but I have not seen her come in yet, and we're still a few minutes early on her.
Are you the attorney for are you Mr. Lettson?
I'm Mr. Lettson.
Okay. Have you seen your attorney?
I've just talked to him. He said he was going to be here after he's about 5 minutes.
We're on the record in People versus Lettson, file number 255389. Can I get counsel for the appearances on?
Here, Coke, on behalf of the people.
Good afternoon, Your Honor. Tyler Below, P75702, on behalf of Mr. Lettson.
I have this set as a plea hearing today. Mr. Vila, how did you want to proceed?
Yes, Your Honor. So we did have this set up as a plea. With further discussions of my client, I think there were some things that he didn't understand. He would now like to exercise his right to a trial.
Ms. Coke, how much time do people think be ready for trial?
Your Honor, I need to file notices now on the domestic violence with his prior cases. I will get that done within the next 30 days. We can have the trial in 60 days. The offer to assault and battery, simple assault and battery, is withdrawn as of today. Thank you.
All right. And how many days of trial?
Your Honor, we're going to ask for 2 days since we're going to be doing the 768 notice on his prior domestic violence.
Mr. Vila, if we set this for 90 days, is that enough time?
Certainly, Your Honor.
Set a trial at 90 days for a 2-day jury trial. I will set it for a final status conference, although it sounds like
the offer's been withdrawn.
Yeah, like there's so not going to be a plea, so that's fine. But we'll set it for a final status conference on the court's motion day immediately prior to the trial date once we get that.
Is there a scheduling order as far as jury instructions?
I'm going, filling that out right now. I'll send that out to you.
Thank you, Your Honor.
And that explains when to submit jury instructions and so forth. So to the extent there are further plea discussions, that final status conference will be the plea cutoff. It'll also be the motion cutoff, so to the extent either side has motions, they need to be filed and heard no later than the date of the final status conference. All the other instructions are in there. Ms. Koch, any other scheduling matters for your side today?
No, thank you.
All set. Thank you, Your Honor.
So the court will send out the trial notice, the notice of the final status conference, and a copy of the scheduling order. Mr. Lettson, do you have any questions? No? Okay, thank you.
Thank you, Your Honor. Have a good day.
Versus Creed, Ms. Creed here.
Mr. Cruz was asking for just one more moment. He's getting people ready for the court's arraignments shortly.
Do you have?
Mr. Roy Smith is here.
Okay, Mr. Smith, would you come forward, please?
We have the headphones, Your Honor, for hearing assistance, please.
Yes.
You can help yourself anytime. Those are in the box. So
Okay.
go whenever you.
I'm gonna grab these, see if they help. Smith, try these on, see if they help.
Can you hear me okay, sir? Okay. So your name is Roy Smith, is that correct?
Yes, sir.
Okay. We're on the People versus Roy Smith, case number 255399. The record should reflect Mr. Smith is present here in the courtroom. And Mr. Smith, did you have a chance to go through the pre-sentence report with your lawyer?
Yeah, Your Honor, if I could, I'd like to make a motion. Mr. Smith had pled domestic violence with an agreement for domestic violence. Mr. McFarland's investigation revealed he's ineligible. I've spoken to the prosecutor and she doesn't have any objection. Mr. Smith could withdraw the plea to domestic violence. She would offer simple assault. You would accept that. And with the court's permission, we'd be willing to go forward with sentencing, but there are some post-conviction differences to that, and that would be our request today.
Oh,
Sarah, I would not object to that. It was part of the plea agreement that he had the 769 deferral. He did have a domestic violence 24 years ago in St. Clair County. We did not see it on the CCH, so we weren't aware of it. And he hasn't had any contact with the criminal justice system since. So we would be willing to do that if the court would accept that. We did try to talk to the victim about it. It was he understood that that's what we were going to do.
okay, so Mr. Smith, have you talked to your lawyer about this change?
Yes.
And is that what you would like to do as well?
Yes.
Okay, so we have Mr. Smith's testimony reserved from the plea hearing. So I think that certainly would establish a factual basis for domestic violence. It would for assault and battery.
I would. It's a lesser included. Yes.
Yes.
Okay, so the court's just going to direct that the plea to the domestic violence be withdrawn and instead guilty plea to assault and battery be entered. Do you have the backbone for that?
I can get to Sarah. I think it's 750.81.
Okay. So we've got that corrected for the record. In terms of changes to the PSI, Mr. Thompson?
No changes to the PSI, Your Honor. We agree it was prepared and scored. Well, not really scored, but accurate.
Ms. Koch, any changes?
No.
And you indicated you contacted the victim, but do you have a victim that wishes to address the court today?
He is not present today.
Anything that you would like to say on behalf of the people for allocution?
You know, I think the recommendation is appropriate. He has minimal criminal history. He's 72 years old. His contact with the criminal justice system has been, over 2 decades ago. I think the recommendation is appropriate. Thank you.
Mr. Thompson, anything on behalf of Mr. Smith?
Yes, Your Honor. I think the court can review the circumstances here and see how this came about. This was arguably a defensible case. Mr. Smith chose to take this misdemeanor plea. I think it's good for everyone involved to put this matter to rest. It's unfortunate when family situations turn like this, but he was obviously very upset that day. He apologizes to the court, and I think it's an appropriate resolution that's been suggested by Mr. McFarland. Thank you.
Mr. Smith, was there anything you wanted to say today?
Not really. It happened and I'm sorry for it.
I did read the report, so I'm familiar with what happened in this circumstance. And I do think that the recommendation is an appropriate way to handle this. It sounds like, the other individual was not in the right state of mind,
Right.
came over to your house, was acting in a certain way, and I think you took some actions to try and, probably protect yourself and your property.
Yes.
Maybe not the best way for you to handle that.
Right.
But I think anybody looking at this could kind of understand why you did what you did, even if it was maybe not the best way to handle it. The best way is always to call the police, have them come and deal with it instead of trying to handle that yourself. But I think that the recommendation is appropriate, and I'm going to follow that recommendation. So the court is going to impose 1 year of probation. The court's going to adopt all the conditions listed in the report for the probation. The court is going to order that you serve 2 days in jail with credit for 2 days served. So no additional jail time. I don't think that's warranted given what happened in this case. The court will impose a crime victims assessment of $130, court costs of $325, attorney fees of $350.
Your Honor, if I could object to that part, I was private.
Oh, okay.
Thank you.
So the court will not impose attorney fees. And then the court will order that the face sheet of the PSI be corrected to reflect that you were retained, not appointed. A DNA testing fee of $60, a $50 state cost, and a supervision fee of probation of $30 per month. You do have the ability to appeal this sentence. If you wanted to appeal this sentence, Mr. Smith, you would have to file for your appeal within the next 21 days. If you have more questions about that, Mr. Thompson would be able to answer those questions for you. Before you leave today, you just need to check in with Mr. McFalda, the probation agent, okay? Thank you.
What else? Yeah, your bond can go towards mine as well. The bond goes in. Yeah. Mr. McFarland's on the outside.
All right, let's talk about that. This session gave us a glimpse into several unfolding matters, but the standout had to be the attempt by one defendant, Stephanie, to reopen her plea, and the absolute resolve of Judge George Mertz in steering that ship straight. The hearing began with Judge Mertz confirming that Stephanie had been given a paper copy of the pre-sentence report and had a chance to review it. But almost immediately, she challenged the contents of the report, claiming it contained inaccuracies, particularly the assertion that she fled the building after saying she wanted a trial. According to her, she had clearly stated her intent to go to trial, but her request was ignored in favor of pushing a plea. Her tone quickly escalated, and despite the judge's repeated efforts to offer her a structured opportunity to speak, she continued to interrupt, getting increasingly combative. Mertz, calm but firm, warned her repeatedly that continued interruptions would result in the hearing being rescheduled. When the pattern continued, he followed through, ordering her into custody without bond and resetting the sentencing for a later date. It was a textbook moment of judicial restraint snapping into enforcement mode. No theatrics from the bench, but the message was clear: decorum matters. And court isn't the place for shouting over due process. We then transitioned into a more orderly scene with People v. Lettson. This case was set for a plea, but after further discussion, the defendant opted to go to trial. The prosecution immediately withdrew its offer, and Judge Mertz locked in a 90-day timeline for a 2-day jury trial. Everyone was calm, professional, and direct. Sometimes plea deals evaporate, and when they do, the court simply pivots. No drama here, just procedural clarity, but the hearing that wrapped everything up with quiet grace was People v. Roy Smith. Mr. Smith, 72 years old, originally pled to domestic violence, but it turned out he had a decades-old conviction that altered the applicability of the original plea deal. With the court's approval, the plea was reduced to simple assault and battery, a lesser charge that still preserved accountability. Mr. Smith admitted guilt plainly and apologized. His attorney and the prosecution both agreed the resolution was fair, noting his spotless record for over 20 years. The court handed down a year of probation, but no additional jail time beyond 2 days already served. Judge Mertz acknowledged the complexity, how this involved a family situation gone sideways, and gently reminded Smith that while his instincts may have been understandable, calling the police is always the better option. All in all, this hearing was a masterclass in courtroom dynamics. We saw one defendant lash out emotionally, another recalibrate their legal strategy, and a third quietly close a long chapter. Through it all, Judge Mertz kept the courtroom focused and fair. No sensationalism, no surprises, just a steady application of the law layered with human understanding. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.